Hi. So today I'm going to share with you about the technique of writing a will deed. Now before that, let us understand how a will deed is written. Will deed can be written on a piece of white paper in front of two witnesses. More particularly, the signature of the person who is writing the will is called the testator, who should sign in front of those two witnesses. This is the fundamental rule for a will deed. It can be registered and it is a better option as per my advice. And preferably the witnesses may be youngsters, so that even after the death of the testator, if there are any problems, the youngsters will be alive, assumed to be alive, because they are youngsters for a longer period of time, so that in future also, if there are any problems, they could come to court and inform the court, give evidence in the court that the testator signed in front of them. If this is particularly for an unregistered will deed, if there is a registered will deed, that problem will not arise, because that is already taken care in the sub-registrar office. Now, this is the fundamental rule of writing a will deed, the procedure of writing a will deed. Now, what is the substantial part? What is the technique? If the technique is not followed, it becomes a breeding ground for litigation. It suffers a court case, because court has to interpret it. So, in order not to come to court after the death of the testator, if a technique, the following technique which I am revealing is followed, is applied, there will be no need to come to court. The technique is very simple. Limit the property given to the beneficiary of the will deed only to one generation, immediate generation. Don't go beyond that, the second generation. That means if a grandfather is writing a will deed, limit it to his son, not to his grandson. To understand it better, I will give you an example. Let us assume that there is a person called Z, he has a wife, and he has two children, X and Y. Both sons, X and Y. X has two sons, X1 and X2. Y has two sons, Y1 and Y2. Now, if Z writes a will deed saying that after the death of Z, the property goes to X. It is a simple will deed with a simple interpretation. After the death of Z, the property goes to X, that is the elder son. It is clear. There is absolutely no confusion. Here, two circumstances may arise. If Z dies, automatically X gets the property. There is no dispute about it from Y, because Y and wife may claim share in the property of the Z. Now, let us imagine if X dies before the death of Z, then will deed becomes cancelled. Will deed becomes null and void, because there is no beneficiary in the will deed, because X died before Z. So now this is clear, because it is written only to the extent of one generation. Now I will give you another illustration. If Z writes a will deed saying that after the death of Z, the property goes to X, and after the death of X, the property goes to X1. There is a confusion here. Now imagine a situation, if X1 dies before X. Now what will happen to the clause in the will deed? How this will deed will be executed? Z died, property came into the hands of X. X is enjoying the property, thinking that after his death, the property goes to X1. Now X1 died before X. That the son predeceased father. Now how to execute that clause? What happens to that clause after the death of X? Grandfather gave to son, son gave to with an instruction that after the death of the son, the property must go to grandson. Here, grandfather died, the property came into the hands of the son. After the death of son, the property must come to the death of grandson. But here, grandson died before son. Now there is no way to execute the will deed. So what exactly happens is the will deed suffers the court case. It comes to court, and court will declare it as void, null and void, or unable to perform, unable to execute the will deed. Therefore, the clause will be declared as null and void, and now the property goes to the legal heirs of Z. Now, who are the remaining legal heirs of Z? The wife of Z, X2, Y, Y1, Y2. So, therefore, if the technique, there are many techniques, but one of the technique for illustration purpose is it should be so clear, so simple. Simplicity is the key. If it is so simple and limited to one generation itself, then will deed clause becomes more legal, more able to performable. The point is very simple. The technique is very simple. It should be able to be performed without any hindrances. It should be very clear. If there is no clarity in the will deed, then many persons will come and take or try to take a share in the will deed. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.